Hi, good morning. Today is October 24th, 2025, and it's 6:23 a.m. U.S. Central Time. And I'm recording this video from my home, located at the 26714 Valleyside Drive, Katy, Texas, 77494. And my name is Rinaldo J. Aguiar Marcano. Um, Today, this is going to be a short but technical session, okay? It's about the textual signal that I created based on the observations of this TTP of filing fraudulent documents in courts that where the title of the document is deceptive. The title does not reflect what the document says, right? And it's a way for them to get rulings and outcomes quickly by tricking the courts, deceiving the courts and the other parties, right? So it's a play on the legal jargon, really, right? On the obfuscation produced by this complicated legal jargon that pro se litigants don't necessarily know, right? Or if they're represented by a lawyer, where the other lawyer is complicit, right? Because the other situation is maybe the other party has a lawyer, but the other lawyer is part of the network, right? So he sees the title and he believes the title, right? Like he doesn't check that the title, if the title matches the content. But I imagine, right, it would be a way of being complicit, because a competent lawyer would check the document, right? Would check the document to see if it's really what the title says, right? I mean, this should be a basic thing for a lawyer to do, right? But anyhow, given that they've done this 2 times in 11 days, right? The first time when Morgan Hybner filed the fraudulent document that had the title Notice of Entry dash Temporary Orders, but it was really a notice of hearing. And the goal of that was to deceive the first appellate court, so they dismissed the writ of mandamus where there was an exhibit attached that mentioned Robert Mueller, right? And the second time she did this was when her law firm, somebody in her law firm, filed a document saying that this was a motion that was agreed for Morgan Hybner to leave the case after I filed the evidence of fraud with the federal court, right, the next business day. And the fraud lies in that I never agreed to that, right? They're implying in the title that I agreed to their motion, and I did not agree to their motion, never, right? And I will never agree. And also, there is an automatic stay order triggered by the Rule 18A, which impedes the judge from signing anything while the motion to recuse is pending. So it's kind of a double, well, it's fraud on the title of the document, and it's contempt of court because they are disobeying an explicit order of a stay, an automatic stay. And they're disobeying it because they want to eject Morgan Hybner quickly from the case before everything catches fire, right? So, but going back to the topic, right? So thinking about that, about the two occurrences, right, of the same exact fraud in 11 days in the exact same case by the same law firm, Adams Law Firm, I did what I always do, right? I try to extrapolate the observation and turn it into a signal, into a data analysis signal that allows detection at a scale. Right? And I created a signal and I name it HybnerBoost. Okay, that's the name I'm giving to the signal to honor Morgan Hybner, because she was the one that illuminated me into seeing this, right? Allowed me to see this, right? So I'm going to name this signal HybnerBoost, right? And it's a signal that basically allows detection of this TTP, right, at a scale. You can do this at planet scale. Well, not really at planet scale. Here I'm going to make a pause because I'm going to say something that it's something that I realized, right, while working on this last night. it's one of those cases where the thing is not fully, fully formed in my mind. The idea is not, but I can see that it's a very fundamental idea, right? Even early on. And so I'm going to say it now in case this information reaches the FBI, they can engage people that know about this stuff, right? And can figure out, can evolve this idea faster than I would, right? And this is a very fundamental idea that has to do with the nature of this conflict, right? And I'm not talking about Rinaldo, I'm talking about in general, right? So let me think how I frame this correctly. The idea has to do with localization, okay? And when I show you the signal, I'll elaborate on what I mean exactly, right? But it has to do with localization, and it has to do with an inherent weakness that the need for localization for detection brings into this problem at global scale, okay? Actually, I think it's better if I show you a signal, right? And I elaborate on that, and then it will make more sense. Also, I apologize. I'll do that instead. I'll show you the signal, and then it will be easier for me to communicate what I mean by this. So to introduce a signal, I'm going to show a document that this signal flagged last night, right? I implemented it and tested it in this docket, and it flagged a document, and it's, I think it's a spot on, right? So it will show the power of this, right? So let me show you the document. So this would be the third instance of this fraud, right, in the same docket. Of this same TTP of filing fraudulent title documents with the court. But this one, I think, is like the bomb, right? Because, this implies coordination with other people. But, the other one, it was only Morgan Heibner, right? Only her signature. The fraud could only be attributed to her. But in this one, I think there is indication that other people were involved, right? So let me show you, right? No, the share screen doesn't want to work. 1 second. Okay, let me do something. Let me close that. Let me open a new window. Let me then share that window. Okay, and now I'm going to open the document. Okay, so this is the document in question, right? So the document, as you see, let me see if I can increase the size of this. Right, so the title, right? This is the subtitle, right? So it says temporary restraining order and order setting hearing for temporary orders, right? So first of all, right? So I'm going to tell you the anomalies in the document, right? And I'm going to talk about the signal, the HybnerBoost signal, and why this was flagged. So anomalies, right? The first one is that this is not really an order, because if you look at this, right, it is not signed, right? So this is really a proposed order, and you can see in the docket, this is index number 5 of April 9, 2025. And you see that it says proposed order in the docket. But she didn't label it as proposed. But okay, you can think that, we can say that, let's assume that that was a clerical, or a form, they don't, The Adams law firm doesn't like to put proposed, right? It should say proposed because it needs to be clear that this is not an order, right? Because otherwise, somebody like me, a pro se litigant, could think that this is an order. But anyhow, let's assume that, right? But then it says temporary restraining order, right? And then in the first paragraph, it says that it is ordered that the above matter is set before the court, right? So this is not really an order. This is I mean, it's an order for setting a hearing. I mean, this is, you know, Morgan, and I know this because I've interacted with the court and with Morgan Heibner, and I've seen Morgan Heibner schedule things in front of me with the scheduler, right? Morgan Heibner has the power to schedule hearings with the judge with 2 days notice. There is no need to create an order to schedule a hearing for Morgan Heibner, right? But the most telling thing, right, is that then, right, in the second page, right, all this is talking about in the first page is this hearing that is going to happen at some point, right? Which is the hearing in which Judge Bell ordered that I went to mediation with the other party while they had a motion for psychiatric evaluation pending against me, right? Which is a form of coercion. How can you negotiate anything with anybody if they're threatening you with a psychiatric evaluation, right? With a forced medical procedure. So he ordered me to go to mediation, right? So this is this hearing, right? That was in this hearing that they're ordering here, right? They're setting the hearing. But then on page 2, right? And this is also interesting, right? Look at the footer of the document, right? It says notice of temporary orders, hearing, and order to appear. But yet the actual title that they put in the document says temporary restraining order. So the footer doesn't match the heading, right? Even in the same document that the Adams law firm produced. And you know, all these are instructions for the hearing. We're still talking about the hearing, even at the half of the second page. Now, after that, it says that a standing restraining order, which is the standard, you know, these are standard restraining orders that the courts have in place for every divorce case, right? And this was attached to this quote-unquote order, right? So these standard restraining orders are orders that all the courts, well, I don't know if all the courts, but at least this court has, right, in place for all the divorces to keep things civil, right? So no party does anything that would disrupt the process, right? Or would, you know, harass the other parent or secret the child, things like that, right? So all those things are explicitly forbidden in this standard restraining order that is part of this court has it, and they signed it. I think it was in 2021. So it's a document that was signed years ago, right? It applies for every divorce case. So what Morgan Heibner is doing here, right, is that she is creating this sham order, right? I mean, she created it, right, and filed it on April 9th. And the date is very important. I'm going to tell you why in a second. But she created this sham order, which is really a kind of a request for a hearing, right, or an order for a hearing. And she put in the second page that the standard restraining orders of the court apply, right? Which, I mean, from a technical point of view, it's odd, right? I mean, this procedure is odd, particularly knowing the powers of scheduling that Morgan Heibner has with this particular court. But you know, it's on itself, right? It's not a crime, right? But then if you go to the docket, right? And now this is the docket. This is the actual docket, right? If you go to the docket, there's several anomalies here. So first, on 4/11, so 2 days later, right? The judge signs the order, right? Here. It says docket entry TRO signed by Judge RB. I don't know who Judge RB is, but could be Bell, right? Because of the B as involved. Bell is the same judge that ordered me to mediation while Morgan Heibner had the weapon of the psychiatric evaluation pending over my head, and the mediation was with David S. Perwin, who was a former judge, who is a former judge, I mean, was a judge before, in that same court. And he was appointed by Governor Greg Abbott. I'm just stating facts here. Like, all these are facts, right? And David S. Perwin, during the mediation, failed to convey a critical request, the only request I made to the other party. He told me that he told the other party what I asked for, and the other party told me in a recorded conversation that they never got that request, right? But anyhow, so the judge, RB, signed this order on the 11th, right? And the docket entry that appears, look at the word, right? It says temporary restraining order. Exactly what Morgan Heibner put as the first sentence in her title, right? This is exactly the same TTP of the notice of entry dash temporary orders that we saw on October 10th, right? That we saw that was entered on October 10th, where Morgan Heibner puts a deceptive title, and that title is put exactly in the docket, and that causes a further action somewhere else, right? The goal here, and this is a hypothesis, right? But I imagine, right, that the goal here is to discredit me, right? Because if a judge in the federal court sees this docket, right, or in any other place, sees this docket, they will think that a judge on the 387th signed a temporary restraining order against me. Like, this is not a standard order, you know, because the standard, the objective of having the standard order that this court has for all divorces is that they don't have to do it every time, right? So they just did it once and applies for everybody, and everybody knows that it applies, right? So there is no need for it to be in the docket, right? But the fact that there's this entry in the docket that says temporary restraining order, index 8 of 4/11/2025, tells the judge this, I mean, some other judge took the initiative of signing a temporary restraining order against this person, right? So this is to paint me as unstable, crazy, to discredit me, right? To validate the narrative that the things I'm saying are not, you know, don't hold any water. But again, it's the same exact TTP of putting a deceptive title, and then that gets into the docket verbatim, right? See, in the docket, and you see there's longer titles, like there's documents that have longer titles, right? In this docket, but so it's not a matter of the number of characters. It's not that it got truncated, right? The clerk deliberately picked only the first 3 words in the title, right? So it said temporary restraining order. Exactly what Morgan Heibner put here. That doesn't even match the footer of the document. The footer of the document doesn't say temporary restraining order anywhere, right? Now, 1 second. Yes. Okay. So yes. So the judge signed that, and it got into the docket. So it's the same TTP. Okay. Now I'm going to tell you, before I talk about the signal of detection of this. So the HybnerBoost. I'm going to tell you the other irregularities that are in this sequence. Okay. So Morgan Heibner filed this document on 4/9. Okay, so April 9, 2025, and it's index 5. It says proposed order, and then it says temporary restraining order, which is not true. This document doesn't have a temporary restraining order. This document, it's talking about the standard orders. See, the standing restraining order. This is not a temporary restraining order, right? Anyway, yeah, and the rest are requests they're making to the court, but it's so this index number 5 is completely misrepresenting the situation, right? Both in the title and in the subheading, right? But this is designed, I believe, to make somebody think that I'm dangerous, right? Now, index number 6 says request for process. Okay. Now this is the interesting part. Okay, this is what I say, that this involves other individuals. Now, if you look at April 10, right, it says there is no signature block for the court. and it's signed by initials MR. And you see this thing with the initials, right? This is what I meant the other day, that I made a request to the court, to the judge, to please spell their full name, right? And I said that Morgan Hybner turned that around and make it into an exhibit to imply that I'm crazy for trying to tell a judge how to do their job. But this is what I meant. The obfuscation of names in court documents is a very dangerous thing because you don't know who's who, right? There could be people with the same initials, right? And then if somebody commits a crime, like Morgan Hybner is doing, and somebody else has the same initials, then I imagine, right, this would be a hurdle for prosecutors because then they don't know who was it, right? So yes, but she says there is no signature block, she or he, I don't know who MR is, right? It's a clerk, obviously, right? But they say there is no signature block for the court, which is not true. If you look at this document, you will see that there is a signature block. It is there, right? So that is a lie right there. And you can say, well, maybe this is a different version of the document. No, because in this document, you see, right, that this document was served here on 4/9, right, at 5:26 p.m. So April 9, which matches the docket entry of index 5, right? You see here, 4/9, right? So this document that they're saying that has no signature block is this document I'm showing you, and you can see that by the timestamp. And you can see that it does have a signature block, right? So that is not true. And you see here that she's saying that this is approved as a form only, right? And it's signed by Morgan Hybner herself, right? With her bar number and everything. Okay. So we keep going, right? So there is something irregular here, right? The clerk is lying about the signature block being missing. Then the judge makes the following entry. There is no independent request for a TRO in the pleadings, right? Counsel should file a notice of hearing for temporary orders or amend the pleadings accordingly. Which is kind of what I'm saying, right? I mean, what he's saying, and this is, oh, this is interesting. So this other entry says that this is a judge docket. So MR is a judge, right? MR is not a clerk, he's a judge. And that judge is saying, well, I don't know, could be the administrative staff of the judge, right? Like the court coordinator. Could be somebody that works for the judge, but it's not the judge directly, right? I don't know exactly how they work inside, right? Yeah. But anyhow, this person is saying that there is no TRO, so why is this called temporary restraining order, right? Exactly what I'm saying. And then, so this is on the 10th, right? 4/10, you can see this. So there's two things that they're complaining about, right? That there's no signature block, which is false. That is false, and it's demonstrable false because I'm showing you the document here with the signature block and the timestamp of the service. That is 4/9, right? So that is false. So this person, MR, already said something that is false in the docket. And then they go on to say that there is no request for a TRO, and it's the same person, right? Now, this is the strange part. On 4/11, so the next day, the judge signs. Sorry about that. Sorry about that. I got disconnected my headphone. Okay. So on 4/11, the next day, the judge signs, and it says temporary restraining order signed, right? So he signed, apparently, this judge RB, who we don't know who he is, right? Because RB could be anybody. So the judge signed that temporary restraining order. But the strange thing is that there is no filing. I mean, after 4/10, there's two comments, right? Complaining about the structure of the document, saying that there is no signature block, which is a lie. There was a signature block. And that there's no independent request for a TRO. There is no other entry. So Morgan Hybner did not file the thing that the judge signed. Or, I mean, there's two possibilities, right? One is that Morgan Hybner never filed the thing that the judge signed, which would be a tremendous violation of the process, because it means that she has an order in her pocket that I never knew that existed, right? How can I even contest it? Or, I mean, she could try to enforce something that is in that order, and I mean, I could be in violation of an order because I was never notified that it existed and it's not in the docket. And she could have that paper signed by a judge in her pocket, right? Waiting to use it against me. So that's one possibility, right? That she got something signed by the judge, but she didn't file it. And she kept it on her pocket on reserve to use it in a case of emergency. Or the other option is that the judge really signed this document that was filed on April 9, right? This deceptive title document that she titled Temporary Restraining Order, right? Temporary Restraining Order, right? It says here Temporary Restraining Order. So it's possible the judge signed this document that supposedly didn't have a signature block, but it does have it. And the judge, because he saw in the title Temporary Restraining Order, he put in his docket entry TRO, right? But this sequence validates to any external observer that I'm crazy because, or that I'm dangerous somehow, right? That I needed to be restrained by a judge. Because the person will see this docket, right? And will see that Morgan Hybner filed a temporary restraining order, and in record time, in less than 2 days, the judge did sign a temporary restraining order, right? So this is a way to create a discrediting narrative using the docket and the obfuscation in the docket and the deceptive titles document in the documents, right? The same TTP that they apply to first get the appellate review dismissed by fraudulent means, committing fraud against 2 courts, and that then they use to try to eject Morgan Hybner of the case in a state of emergency when there is an automatic stay on the case, right? Saying that I agreed to the ejection of Morgan Hybner when I did not agree, and I will never agree. So, but you see, it's the same TTP, right? Now, I think this is something that needs to be reviewed by authorities. I'm not, in a position to understand what was the sequence here. I mean, I cannot even see the full names of these people, right? I don't know who's MR, who's RB. It's not clear here, right? And the judge. So I guess the point I'm trying to convey is that if MR on 410 made 2 entries saying, and it says judge docket entry. I don't know if that's a judge, but that person said 2 things that were wrong with the document. And the next day, the judge, RB, signed the order. It's implied that something must have happened between the 10th and the 11th for the document to be corrected, right? The anomaly lies in that there is no entry for such correction. Where is the index number 7, right? You can see there's index number 5 here, index number 6, but there's no index number 7. And then we jump to index number 8. And then you could say, well, maybe these 3, maybe this is index number 7, right? This judge docket entry, but that would be illogical because then, I mean, if those judge docket entries cause an index increment, then there would be 3 index increments because there are 3 of those nodes, right? Those entries. So it would have jumped from index 6 to index 10, right? But it went from index 6 to index 8, right? So there is a missing index in the middle, 7, which could be the fixed document, right? The supposedly fixed document. I'm saying supposedly because the original document didn't have a problem. It did have the signature block. It is there. You can see it there, right? You can see it there, right? It has sign, at, and it has even the time, to put the time where they sign, right? And then, for the judge to sign, right? So this is a lie, that there was no signature block. I think, and this is a theory, it could be just a way to justify the appearance of this mysterious document that is not in the, right? Like they could say, right, if they're investigated, they could say, oh, oops, there was a mistake in the document and we had to fix it, but there was a problem in the filing, and the document did not get filed correctly. Index number 7, right? Which is the one that would be missing. It could be a plausible explanation for what seems like overt fraud, right? In all fronts. But again, I think that fails because what they put in the docket saying that there is no signature block, it's false. There is a signature block. And you can see that this is the actual document because you can see the timestamp of the file, right? This is the document, index number 5. Now, another thing that's interesting, right? That when they did all this, this is another point. So you see, this document, right, wasn't served to me electronically. Morgan Heibner had my email because I had given her my email address, but she did not serve me electronically with this. She sent the process server on April 16. So we're talking about 5 days after she got that signed by the judge on the 11th, right? She sent the process server to serve me documents, and this document is what I got in that package from the process server. That's how I have it. Otherwise, I would not have this document, right? Because it was not served to me electronically, as you can see in this electronic receipt, right? Only Morgan Heibner and Tina Simon were served with the document. I wasn't served. So I got served physically by the process server that Morgan Heibner served to my house on April 16, a little bit past 9 a.m., 20 minutes after I started doing programmatic calls to Google Maps API to reverse your code addresses of Diosdado Cabello's agents in Caracas. Right? 20 minutes after I started doing that, Morgan Heibner sent me a process server to my home to harass me and serve me with this document, among other documents. Right? But this is telling, right? Because she served me physically with a document that wasn't signed by a judge, and according to the docket, again, she has a document signed, right? As per 411. So why didn't she give me the copy that is signed? Right? Which I imagine is the missing index number 7, right? This mysterious index number 7 that is missing, right? In the docket. It's not there anywhere, right? Right. Well, actually, this is a good point, right? We can see the other docket entry from the judge from 9/11, right? To see if the index increment. You see here, right? You see, yeah, you can see here very clearly. So this is so on 9/11, right? So this is when the judge, Oscar Telfair, entered in the docket his notes for the temporary orders that are in effect, that are verbal, the cause of all this debacle, right? Because they are not signed. They're just verbal orders. Still at this point, after, I don't know, 44 days, right? And the orders are supposed to last 60 days in total. So we have only 16 days remaining on the orders, and the orders are still not signed, which make them unappealable, right? So these are orders that nobody can appeal or review, right? But anyhow, the judge made this entry on 9/11, and you can see that before the entry, the index in the docket was index 54, and right after, the index is index 55, right? So a judge, what I'm trying to say is a judge entering notes in the docket, a judge docket entry, does not, in this particular system, right? This is specific to this software system that they use, does not automatically increment the index. You can see it here, right? Before the judge entry, it was 54, and after the judge entry, it was 55. So there was no increment. So there is no reason, right? Because it's the same software system, right? Logically, you would think there is no reason to jump from index 6 to index 8, no matter how many judge docket entries they put in here, right? So there is a document that is missing, the index number 7. Morgan Heibner must be hiding this document, right? And it's a mystery to me what is contained in this document, because she never sent me that document. She sent me the document index number 5, right? This is what she sent me. And you can see it. You can see it was that because, again, the timestamp in the service. That doesn't lie. She could not have served me a document that wasn't produced until 2 days later by pure logic, right? So, I mean, there's so many violations here, right? She having a signed copy from a judge, she served me the unsigned copy from 2 days before. And according to the docket, this is not the version that the judge signed, because there were entries made that implied that corrections were needed. And then the judge signed. And also, so maybe what the judge signed was really a temporary restraining order, right? It's possible that they, after the index 5, when these docket entries that say that there's a missing signature block, it's possible Morgan Hyman created a real temporary restraining order, stripping me of I don't know what rights, right? And then got the judge to sign that, right? But she never gave me that. It's not even in the docket, right? Not even in the online docket, right? So she might not even have filed it, maybe, right? So maybe she has it in her pocket, I don't know, in her house. Who knows where she has it, right? But the other option is that she did get this document signed, right? This document index 5, which is not really a temporary restraining order, right? But regardless of what was the path that they took, the outcome is the same. If you look at this docket, it looks like a judge signed a temporary restraining order against me, right? But none of the documents that are available to the public and to me say that. The only person that maybe has this mysterious temporary restraining order is Morgan Hyman, right? Because she didn't file that with the court. Or she filed it and then was removed. That's the other thing, right? Because you would think, yes, I think that's probably what happened. Because this is a software system, right? And I'm telling you this as a software engineer. If you have a system that increments the indices in this way, right? If she filed the document, then that would create an index increment, creating the index number 7, and therefore the next document would be index number 8, right? So it would make sense. But the fact that it's now missing, what it suggests to me is that maybe it was removed. The index number 7 was removed for some reason. And because otherwise, in this software system, if it was not filed, it would not have caused an index increment. And then this temporary restraining order here would really be named index 8, right? Yes. So there is a document, a proposed order, index 7, that is missing, right? The proposed order is what's missing, because she had to file the corrected document as a proposed order so the judge could sign it, right? So the question is, if that index number 7 that is now gone from the summary, from the docket, matches the temporary restraining order here that says temporary restraining order on index number 8, right? Which I suspect is this one, really, because this is what she served me, right? She's not going to give me a document that incriminates her, right? So I think probably the judge signed this. I imagine, right? I don't know. I wasn't there, and they never gave me the document with the signature, right? And there is a document missing in the summary, in the docket, the index number 7, which should be what she really proposed, right? That is gone from the record. But you can see the TTP, right? So the TTP really, bringing this back to the TTP, the TTP is creating a deceptive title, right? Where the first phrase says what you want to appear in the docket, right? I mean, right? What they want to make appear in the docket, that's the first phrase they will put, right? And then a bunch of things that are confusing and may not even make legal sense, right? And then coordination, obviously, right? There has to be coordination because, and I'm saying this based on the fact that this person, MR, is saying that there is no signature block for the court. And that is not true because, again, you're seeing the document here with the timestamp of April 9 that has the signature block, right? Sorry. So for all this to happen, right, there has to be coordination, right, between the people making these entries, Morgan Hybner, and the people, the clerks that are putting the docket entries, right, with the titles that are decidable to Morgan Hybner, right, like the temporary restraining order. That's decidable to her because it's a way to discredit me, right, and to fabricate a narrative that favors, Robert Mueller and Phil Denning and the other lawyers. So I don't know. But let's talk a little bit about well, before I go into the actual signal, right? And the other observation that I have let me say that the timing of all this is important, right? Because remember, I reported Diosdado Cabello to the IRS on the last week of March, right? It was on the 22nd. I have to check the date, but it was in that week. And you can see the filing, right? Like you can go to form211.org, and you can download this is the file that I sent to the IRS, right? It's an immense file with evidence, right? Like with some entries of my counterintelligence journal that I picked to attach to this, and the full list of names and properties, right? And you can download the full form at form211.org. So I sent this to the IRS on the last week of March. I think it was around March 22nd. I have to check the date. But then, right, if you look at the summary, just say, so my son was taken from the home on March 28th. So shortly, 5-6 days after I filed that with the IRS. And then just 9 days later, right, Morgan Hybner was already proposing this temporary restraining order, which is not really a temporary restraining order. It's just a standard order and a request for a hearing. But she titled the document as a temporary restraining order, right? So you see the cause and reaction, right? It's obvious, right? And this is crucial because it implies that this state litigation that they have going, right, to strip me from my parental rights and call me crazy and all that, it was by design from the start, right? Because just at index number 5, Morgan Hybner was already committing this fraud with the title, right? Because you could think, right? You could make the argument, well, maybe the litigation was legit and Morgan Hybner got bribed in the course of the litigation, right? Or got compromised, like they paid her a tremendous amount of money to make her do these things. But you can see here that that's not the case, because at the very beginning of the case, just in index number 5, she was already committing fraud with the titles, right? To call me crazy and to fabricate this evidence of mental illness that she knows doesn't exist, right? And again, I think I mean, I don't know, like I don't know how. When this inevitably goes to the DOJ, right, and the prosecutor takes the reins of this, right, because which is what I imagine is going to happen, right, at some point. I don't know how they're going to play it, right? I have no idea, and it's not my place to say anything about that. But if I may offer an idea, right? The fact that she was designing this from the very beginning to call me crazy and subject me to a forced medical procedure is a grave, I think it's a grave transgression of international law, because I am a protected refugee. I'm a refugee, a political refugee that claimed refugee status against Diosdado Cabello and all his group, right? Years ago. And she's doing all this intentional design and putting all this engineering and deception with the goal to subject me to a medical procedure, a forced medical procedure that I don't need, right? So I don't know. I think it could be a tremendous ammunition against her personally, right, to make her talk. But anyhow, it's just a thought. Okay. So now I'm gonna transition more to the technical aspect of this and that idea that is resonating in my head, right? It's a chilling idea, really. So let's go back to the document, okay, to talk about the detection. So this is how the signal works. I mean, this is the prototype, right? This is the way it works right now. So it uses. And now, I'm talking more to the audience of potentially, I don't know, Google engineers, right? That I'm going to use some technical jargon that may not make sense, and I don't want to explain everything because it would make this too long. So I apologize in advance for that. But if anybody from the authorities gets this video, you need to get a Google engineer from, I would say, from the Q Rewrite team and from the knowledge graph team, probably, right? Some people that works in natural language understanding. So the idea here, right, is to do entity recognition and topicality analysis on the title, standalone, just the title, right? So in this case, temporary restraining order and order settings hearing for temporary orders. If you do this, you will get an entity for temporary restraining order, you will get another entity for order, and you will get another entity for hearing, and another entity for temporary orders, okay? And if you do this with the current implementation of Google Knowledge Graph, you will get topicalities that would be something like 0.8, 0.5, 0.3, and 0.1, right? In that order. So obviously, right, just by looking at the title standalone, this is something that is strongly about temporary restraining orders, right? This document, right? And then you do the same with the first 4 or 5 paragraphs of the document, okay? If you do this in this case, you will see that the topicality and the entities that get recognized for the first 5 paragraphs are about a hearing, right? So there is an immediate disconnect between the topicalities of the title and the topicalities of the first five paragraphs, okay? And that gives it away immediately, right? Because the title is talking about strongly temporary restraining orders, but the first 5 paragraphs are talking about setting a hearing, right? And rules for a hearing. So this is a giveaway. And if you apply this signal to the 3 fraudulent documents that Morgan Hybner has filed, that I have identified so far, maybe there are more, right? But that I have identified so far that she has filed in this case, all the 3 would be flagged by this algorithm, okay? So basically the idea is that the top 2 entities, the algorithm specifically is that the top 2 entities in the title match the top 2 entities in the first 5 paragraphs, and is that their topicalities are aligned. If they're not aligned, it's also flagged, okay? So so that's the algorithm, right? And you can use this. It took me 20 minutes to write this, right? Signal. So imagine, right? A team from the FBI can do this and do this at countries in the entire United States in 2 days, right? I don't know, something like that, end to end, right? I don't think this would take more than 2 days, and this is important because this would allow you to identify other targets, right? I'm not thinking about catching the perpetrators. I'm thinking about helping the targets, right? Because if they're applying this to somebody, it's because that person is being targeted, right? So that's the method of detection. But this leads me to a thought that, to be honest, I think it's going to be difficult for me to convey that idea. Okay, I'm gonna try, but it's not something that I can articulate easily. I don't know. I've been trying for an hour to think how can I say this in a way that makes sense, and it's hard. It's hard to come up with an analogy, even, right? But I'm gonna give it a try. So the observation, and this observation I'm going to tell you, comes not from engineering, but from, well, a little bit. I saw this at Google, right? But it comes more from being a second language speaker of the English language. Okay. So the observation is that in different languages and in different cultures, people write and speak differently, inherently differently, right? And I know this because even myself, right? Like if I'm writing an email in Spanish, I do it completely different. Like the way I structure the email is completely different. And this is relevant because of the first 5 paragraphs in my signal are important, right? So it has to be those 5 paragraphs, right? But that is a fact that I think only applies to English, right? And maybe some other Germanic languages, right? But not to all languages. This is not true universally, right? So if you try to, what I'm trying to say is that if you build this signal and you try to apply it in Venezuela, it will not work, right? It will just not work, right? Or if you try to apply it in Spain, right? It probably won't work. And I only know 2 languages and a half, right? English, Spanish, and half of French, I would say. But I can tell you in French probably wouldn't work as well, right? Because of the design of this has to be in the top 5 paragraphs, right? That's embedded into the signal itself. And the reason is the way people think culturally when they write things, right? And well, again, this could be different in the legal, maybe, right? What I'm saying is from observation of written and verbal communication in Spanish with people, right? But maybe in the legal profession in Venezuela, maybe the writing is different. But I don't think so. Like I think it's the same problem. So the observation is that, for example, in Spanish, right? You see, in English, when you write something in writing, right, like a document, you tend to structure it's like when you read a newspaper, right? You read the heading, and that's why the title is important, right? Because it tells you immediately what is this thing about and lets you quickly decide, is this something I want to spend time reading or not, right? That's why they attack the titles on the documents. They weaponize them because of that very same reason, right? And then if you read a newspaper in English, right, in the first paragraph, it tells you high level, what is this thing about? What is going to happen in the next N paragraphs that you're going to read, right? And, depending on the narrative style and the writing style, it's possible that there are some twists at the end of the document, right, that you won't be able to discover unless you read the whole thing. But in general, right, I would say 99% of the English writings, if you read the title and the first 5% of the text, you have it's like, that 20%, 80% rule, right? Like if you read 5% of the text in English, and in English, an average, let's say, English text, if you read the top 5% of the text, you should get about 80% of the understanding, right, of what is this thing going to talk about. And then at the bottom, they give you the details, right? So this is why this signal works very well in the English legal corpus, right? But initial tests that I've been doing this morning tell me that probably the precision is not going to be very high in the Spanish language, Spanish legal corpus, right? And the reason is cultural. In Spanish, we try to think, we tend to think differently in the sense that we tend to first give you a lot of details and context and then tell you the idea, right? And you can see this in legal filings in Spanish. Like if you see like a birth certificate, right, in Spanish, they start talking about the parents and, where the parents met and where they married. And then at the end of the birth certificate, they mention the child, when the child was born, and the date, right? This is placed in the second page. In the first page, it's all about the parents, right? I'm not saying that we Spanish people do it different. Like I'm saying, it's just a cultural difference, right? It's just a different way of presenting ideas, right? And this is cultural. So if you apply this signal to a birth certificate, it will fail, right? Because in the first paragraph, it's not even talking about the child, right? It's talking about the parent. If it's a Venezuelan birth certificate, right? But if it's an American birth certificate, in the first paragraph, the first thing it mentions is who's the child, right? And what color are the eyes, and things that will not change quickly, right? So it's just a different way of presenting information, right? But this makes the signal vulnerable for other locales, right? Now, and this is the thought that doesn't that I don't, it's not fully formed, right? But you see, this organization obviously is a global network, right? And you need global mechanisms to counter it, right? And if you apply this logic, I guess what I'm trying to convey is that, say that the FBI gets this information and they build this signal, right? It will only work in the US, right? Probably, because it will be heavily tailored to the customs of the legal profession in the US, and it will only work here. Or it will only work well here. It might work well, more or less well, in Canada and the UK, right? But it will work better in the US. And this is exactly the same problem that Google has, right? Like the precision of Google search is 98% in NUS, right, in English US. But the precision decays in other markets. It's not the same precision. Like even in Canada, the precision of the results is not the same as in the US. So this is a well-known problem in information retrieval systems, right, is what I'm trying to say. But the thought is that this is a criminal network that is operating globally, right? So to really counter it, it needs collaboration, right? It needs, I mean, this signal has to be worked on, not by the FBI, right? I mean, yes, the FBI probably will want to do something with this, but it needs to be a collaborative effort with equivalent agencies of other countries, especially the ones that speak other languages, right? Because otherwise, what will happen is that they will move, right? They will be deterred from doing this in the US, but they will use the legal system of other countries to circumvent and then harass people and companies and do the same thing, but in the legal systems of other jurisdictions that don't speak English, where the signal doesn't work that well, right? Where the system is still vulnerable, right? They will move the angle of attack, but at the same, it will prejudice everybody, right? Because as long as they're doing this, everybody can be a target. Right? So it seems to me like the challenge to overcome, to create a universal vaccine, right? And this is just an example in the legal area, but I imagine that there will be other areas, like law enforcement, for example, right? Where the same problem will happen, right? Like if you try to do detection on, police reports that could be weaponized in a similar way, the detection mechanism will be very different. I mean, the signal needs to be calibrated, right? Or tweaked to be applicable to the police systems of countries that don't speak English, right? Because of the nature of the language differences, right? And this is what I was saying, that you need to talk to somebody from the natural language understanding team at Google, right? Because they deal with this problem every day. They have frameworks that allow them to configure their systems, their distributed systems, to account for these differences in writing systems of different cultures, right? They have technology to solve this problem. Frameworks. I mean, it's not a software, it's a framework, right? They have frameworks and ways, methodic ways of approaching the software problem to tackle this difficulty, right? So they already have that built, and it took them years to build it, right? So there's no need to reinvent the wheel. That's a key piece that you need to leverage in this fight. Those frameworks that they have at the natural language processing team at Google. And I think, from what I recall, I think that team was part of the QRewrite team, if I recall correctly. I'm not sure. Maybe they moved. Sometimes they reorganize things and they move things. So it's in the knowledge organization. It's either in the knowledge graph team or in the QRewrite team. I think it was called Query Understanding, and the broader team, but I don't know. But those frameworks are key to be able to really scale and internationalize this HybnerBoost signal, right? To detect this at a scale, planet-wide, to identify the targets, right? So you can free them. Yeah. So that's more or less the idea. So again, this is the Morgan. So this is the HybnerBoost signal. And the idea is that it boosts the score of documents in the pipeline that exhibit this fraudulent pattern that seems to be the signature of Morgan Hybner. And in this particular case, the timing is important because this happened, of this document, right? It happened days after I filed that IRS report, right? So there's also legal jeopardy there because, legal liability, I mean, because if it's demonstrated that she did all this starting from the index number 5 to silence me, that would be tampering with a witness, right, or silencing a whistleblower, right? It's a federal crime. And yeah, so the timing is important, right? And in this particular case, I think it's even more serious than the other one, because I mean that one is serious because it was fraud upon two courts, but this one is more serious because it clearly shows that there was tampering with the docket. Like there's an index that is the index 7 is missing. The person named MR is putting a note in the docket that is not true. It's demonstrable not true, right? That this document served on the 9 did have the signature block, and the sign order wasn't served, right? It's not where is it? And the proposed order that result in that sign order is not in the docket. It's missing the index 7, right? So I mean, it seems to me like it's a bomb, right? It's a powerful ammunition, legally speaking. So I hope that authorities use it, right, to solve this problem once and for all. Well, thank you so much for your time, and I'll see you on the next one.